Has it ever happened where an injured patient has been offered millions of dollars before trial to settle their case? They reject the offer and then the jury comes back and gives them a big fat zero, nothing. Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, it has happened. Now, it doesn't happen that often. But here's the scenario. So now, let's say you bring a lawsuit for claims against the doctor or the hospital staff, claiming that they were careless and violated the basic standards of care, causing you significant harm and injury. The defense refuses to acknowledge they did anything wrong, which means your case is going to trial. All right, so now 2 or 3 years later, when your case finally gets to trial, before you actually start jury selection, before your attorney starts jury selection, the defense makes you a significant offer in the 7-figure range. He offers a few $1 million to settle your case. Now, your attorney comes back to you and tells you about that offer. He's obligated to tell you about any offer that's made. Your attorney has an obligation to go ahead and discuss with you the settlement offer. And now he's going to tell you about the risks of not taking it, the benefits of taking it, as well as the alternatives that are going to occur, which is likely that you're going to go to trial. And now a jury is going to make that decision on whether or not you are entitled to receive any amount of money. You decide in your infinite wisdom, after having this conversation, that, hey, this offer is insignificant, or this offer is not appropriate. They're not offering you enough, or what you perceive to be enough to settle your case. And you tell your attorney to reject their offer. Now, the attorney wants to know, will you counter what they are offering? And again, you decide for whatever reason, no, I'm not countering. I want the jury to put a value on my injuries. Okay, so now what happens? So now you and your attorney go forward with the trial. The trial lasts weeks, and now this is an emotional roller coaster for you. There are times during the trial where you will be on an emotional high, and there are times during trial where you will be on an emotional low, thinking that the world is ending and you are definitely losing your case. During the course of trial, the defense attorney again tries to engage your attorney in settlement negotiations. He tries to get your attorney to go ahead and accept, and get you to accept, the offer that they made prior to trial. And you are absolutely furious. You are incensed that they have not increased their offer dramatically. You turn around and say, I am not accepting their settlement offers. Tell them to take a hike. I want the jury to come back with a verdict. Okay, now your attorney relays that information to the defense, and now you continue forward with trial. Okay, you've now reached the end of your case. The attorneys have made closing arguments. The judge has now given the jury legal instructions and told them they have to answer a series of questions. And those questions must be answered in a very specific order. And the first question the jury has to answer is, was the defendant negligent? Meaning, was the doctor whom you sued careless? Did he violate the basic standards of medical care? If the answer is no, that's it. Your case is over and you get nothing. If, however, the jury does say yes, the doctor was careless, now they are required to go on to question number 2. And what's question number 2? That involves something we call proximate cause. Was there a link between the doctor's carelessness and your injury? If there is, now they go on to question number 3. But guess what? If there is no link between the wrongdoing and the injury, your case is over and you get a big fat zero, nothing. It is only if the jury answers yes to the fact that the doctor was careless, and yes, his carelessness was a cause of your injury, only then is the jury permitted to go and answer a series of questions about how much money you are to receive for all of the injuries and harms and losses that you suffered, all because this doctor was careless. Let's go back to the question I raised in this video. Is it possible for the defense to offer millions of dollars to settle your case? You reject it, go all the way to trial, and now the jury comes back with a big fat zero? The answer is, yes, it is. So now the jury is out deliberating, and within a very short time they come back with their verdict. And now the verdict is read, and the judge asks the jury foreperson, was the defendant negligent? And his answer, no, he was not. And now the judge says, ladies and gentlemen, thank you so much for your service. This case is done and finished. You can all go home. And you are left stunned. You are shocked. You can't believe your ears. How could they have done that? How could they have found that the doctor was not careless when here they are, their defense attorney was offering millions of dollars to settle this case? You want to know why? The jury can do whatever they feel is appropriate. And if the jury decided that, hey, this doctor was not careless, you get nothing. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.